another little ditty about things to check on your appeal, your ALJ denial letter, if you've gotten a denial. As I've always said, always read through it line by line. I mean, it might take you a while because you're not used to the lingo. Just do it, just slowly but surely, and just try to, think about what certain statements say. But here are the things that you might want to look at, because if you are thinking of appealing that to the appeals council, and I think there's a video about how to kind of help make that decision of whether you should be appealing to the appeals council, if you must appeal to the appeals council to keep your case alive, or if you have other options. So, including refiling. But sometimes you don't have an option to refile, and you must go to the appeals council because that is the only straw left. That's your only remaining card. So anyway, if you look at your ALJ decision, we've already had 2 prior videos on looking at your RFC paragraph or section that's bolded out with the residual functional capacity decided in that section, and you'll see that in the bolded area, as well as the section on looking towards the end of it, where the judge actually describes which 3 occupations he found you could do, okay? And some guidance on there, what to look for. In any event, the other thing you need to look at, or at least one more thing, but there's probably more, so we'll see, is looking at the section, and this would be before the part about the RFC. So a different bolded area where they talk about your medically determinable impairments, MDIs. So there the judge is going to list them, literally 1, then a comma, then 1, then a comma, then 1, then a comma. So you want to get them, put them in a little list, and then think about what impairments you have that he did not list. And in fact, that would be severe impairments he's talking about, because if you look at the sequential evaluation process, the steps in that, I think we have another video on that. I'll double check. If not, I'll get one out eventually, sooner, hopefully, rather than later. But one of the earlier steps is, does the person have medically determinable impairment that is severe? So there's where he lists the severe medically determinable impairments, severe MDIs, as opposed to non-severe MDIs. So I would be looking at 2 things. First, in that bolded paragraph where the severe MDIs are noted, are there any missing that you think are severe? In other words, do they impact your ability to do even something you don't have to do that much for a particular job out there, but even it's not even about your old job, but a different job you wouldn't be able to do because of this. That could be a severe medically determinable impairment. And by medically determinable, it has to be in your medical record. So it can't just be you saying you have it. Did your evidence show this? So you need to have your whole file. You should have gotten a emailed version of it, or a CD, or some other way of getting it from your Office of Hearings Operations before your hearing. Hold on to that. If it's on CD, you want to get that opened up and put into the big, beautiful PDF that it becomes, whether you can do that yourself, or if you have to take it to, some sort of company like a Staples or something, and get them to either print out the whole darn thing. I don't really advise that. If you have a device, you can actually get it onto maybe a thumb drive, and then I would save a backup or 2. The big PDF, I mean, it could be 1,000 pages, it could be more, it could be less, but you should be able to have it saved digitally, so that when you go on a device, you can pull it up, open the PDF, and there you have exhibit after exhibit after exhibit. There's a table of contents, and you could see the last section would be section F, and that's all of your medical evidence laid out for you in sections. Like, so Dr. Jones from this date to this date, so-and-so hospital from this date to this date. So that's something you're going to want to make sure. And again, this is stuff that should have been done before your hearing, but I know sometimes you might be getting to it late in the game, or didn't know. So you're going to look at that severe MDI list the judge gives, and you're going to want to, if you in your mind know that you have other impairments and they're not considered severe, think about whether they are, and if that should be part of your appeal argument. Because failing to find something severe that is, and that the medical evidence clearly shows is. And again, that might be a matter of discretion, but it might be that he didn't consider it at all. Or if he did, he didn't consider all the evidence that would have pointed to a totally different finding. So anyway, just something to look at. Are all of your severe MDIs listed there? Now, some could be listed as non-severe. And those, look at those and see if you beg to differ with the judge's assessment that they were non-severe. And lastly, some might not be noted at all. Sometimes entire impairments are just totally left out of the finding of medically determinable impairment in that section. And that, I think, can be an appealable issue also, because all impairments have to be considered. They can be rejected as severe. They can be found severe, but still you're not disabled, even when including them. But they have to be considered and then explained as to whether they're severe or not severe. So if they're totally left out, that's a big thing to me, particularly if look up all of your impairments if you don't think you know them from your medical records. And also, remember that to be disabled, the impairment has to have lasted 12 months. So something that lasted a week might not be, what we're talking about here. We're talking about those chronic, long-term, less than perfect pieces of our body or our bodily systems. So those are the things. Medically determinable impairments. Make sure none are left off. There frequently are ones left off. So, and you might see ones in there that you're like, well, I don't even think that's one's a big deal, but he considered it severe and da-da-da. That's all fine and good. But you want to hold them to task on all of the impairments and make sure they are either found to be severe or non-severe. And if they're found to be non-severe, do you disagree? Okay. All right. Big, important one, guys. Talk to you later. Bye.